We will call our next case, People versus Veach. Good afternoon. This is a 15-minute mini oral argument on the application, and you have 2 minutes of a free fire zone and may reserve time if you're able.
Thank you very much. Stephen Helton of the State Appellate Defender Office on behalf of Mr. Veach. I'd like to flag for the court that Mr. Veach's mother and sister are here in the courtroom, and I'd gladly waive any free fire zone. Mr. Veach is asking the court to apply the law as it's existed for at least 4 decades regarding the scope of a waiver of a constitutional right, the procedure that must occur before a courtroom can be closed to all members of the public during a criminal trial, and the appropriate remedy where that procedure isn't followed. In asking the court to affirm the Court of Appeals decision in this case and to adopt its holding in Klein, the prosecution's asking the court to make the public trial right substantially weaker in Michigan than in every other jurisdiction in the country, to create even more confusions in trial courts about their obligations when a motion to close a courtroom is filed, and to interpret the Sixth Amendment and the 14th Amendment in a manner that's prohibited by binding United States Supreme Court precedent. The only justification they provided for why the court should ignore the Supremacy Clause and over a century of its own precedent is that granting Mr. Veach relief would cause the complainant undue emotional harm and trouble. This court's adherence to existing law will not be responsible for this, and Mr. Veach's invocation of his constitutional right won't be responsible for it either. The trial court is responsible because it failed to utilize the procedure outlined in Waller, Presley, Vaughn, and Weaver. And the Court of Appeals will be indirectly responsible because its ruling in Klein cast doubt on whether the right to a public trial is fundamental and sowed confusion about what, if anything, trial courts must do before infringing that right. The court can spare witnesses in future cases discomfort and aggravation of having to testify again by issuing clear guidance to trial courts so that they don't needlessly violate public trial rights in future cases. The court should do this. It should invalidate Klein's amorphous definition of partial closure and reverse Mr. Veach's conviction. Thank you. That said, Mr. Veach is sympathetic to Klein's concern that not every closure of a courtroom should necessarily result in a reversal of a conviction. But I think what it did that has created this issue is that certain actions by the court that just that would not qualify as an infringement of a public trial, a bench conference, questioning of a jury member in chambers, these sorts of things, removal of a disruptive witness. In most jurisdictions, those are called, they fall under the triviality exception or they're a de minimis violation. But it's kind of defined those as partial closures and created an entirely new procedure. And so I think just by clarifying that this isn't a partial closure, this isn't a infringement of the public trial right at all, the court can simplify things for trial courts and ensure that they know what their obligations are. And so, I guess in determining whether or not this right is even implicated, the court should look to whether or not this is traditionally open and, whether the action denies the defendant the protections that the public trial right provides. So, when individuals are excluded from the courtroom for disruptive behavior, or witnesses are sequestered, the defendant still receives the protections of a public trial right. because the public isn't generally excluded, certain people are. And, you know, when a legal argument occurs at a bench conference, or when a juror is questioned about threats in chambers, these aren't situations in which the public has traditionally been allowed to participate in view. Michigan statute is more restrictive and provides less options, fewer reasons that a public trial right may be infringed than are set forth in Weiler. There's only three situations, and every time that the courtroom's closed, the trial court is supposed to provide notice to SCOW so that this can be kept track of. We know this isn't being followed. This didn't occur here, and so there was no basis for this closure. And I don't think this is a close case, and so we'd ask the court to reverse.
Could there have been alternatives that the trial judge could have explored that could have justified closure here?
It's difficult to say without the court having identified that interest that's being protected, but just, I guess, as an example, saying what the Court of Appeals said, which was to prevent, trauma to SB and to, I guess, prevent intimidation by Mr. Veach's friends. Yes, a less restrictive means of preventing any threats, if there is actual proof of it, would be to exclude those individuals who might be threatening the witness. In terms of making SBs as comfortable as possible during while she testifies, part of the public trial right is designed to enhance the truth-finding function of trials, and the truth-finding function of trial is the purpose of criminal trials, and so witnesses are supposed to be uncomfortable. That's what In Ray Oliver says. That's what Waller says. Is that having
uncomfortable because of the proceedings, but uncomfortable because of who's present in the courtroom?
Yes, knowledge that the public can observe what you're saying. In Ray Oliver says, these eyes on you, knowledge that the public is going to be watching, it discourages perjury, and it also encourages people to come forward.
So agreeing with you that those are the reasons for having a public trial, can psychological well-being of a witness meet the overriding interest standard in Waller?
Globe talks about this, and it says that it can in certain situations. Michigan statute doesn't provide for that, but yes, but it has to be on a case-by-case basis, and that's exactly what Globe said, which was.
Counsel, it's a tough balance, isn't it? That's the challenge with this case, is that it's a very difficult balancing test, isn't it? To try to figure out the openness of the trial versus the protection of the folks that are involved versus the sensitivity of the matter that's being described. It's a delicate balance, isn't it?
I mean, I think it is a delicate balance, but I don't think this is a close case. The procedure that has to occur, before any sort of trial can be closed, is that there has to be a hearing. There has to be evidence presented to establish that the state has this interest. There wasn't a hearing, and there wasn't any testimony at the preliminary examination from SV saying, I can't do this in public. Mr. Veach's friends and family have been threatening me, anything of that nature from which that could be established. So without actual support for the basis of the closure, it's difficult to determine whether or not that is an overriding interest that overrides.
But there was a stipulation at the exam, is that right?
Yes, and
each of the exams, there were more than one case here, right?
In all three of the preliminary examinations, the defense agreed.
So that would be a reason why there wasn't much discussion about it at that time, right?
I suppose that's why there wasn't discussion of it at the preliminary examination, sure. But upon Mr. Veach's objection, There should have been.
Well, no question, there's no question the trial judge should have done more and didn't make the requisite findings or consider alternatives. I don't even think is in dispute. The question is, well, one question in my mind is whether the closure was otherwise justified. In other words, if there had been a discussion about it, would the judge, even though this didn't fit neatly under the statute, does that statute limit the entire universe of situations in which there can be a closure for purposes of protecting a victim? This victim is only, a little bit outside the age in the statute, right?
Well, there are two different statutes that are at issue. 600-1420 lists 3 bases for closing, and then there's the 600-2163 A, which lists says that trials or hearings can be closed for vulnerable adults, or and that it may be closed for minors. No, none of these statutory mechanisms provide for the closure. But more to the point, there just isn't. Globe is very clear that there cannot be a rule that we automatically close the courtroom whenever a minor sex crime victim testifies. There has to be a case-specific analysis supported by evidence. At the preliminary examination, Mr. Veach did not have a personal right to a public hearing. The public had a First Amendment right to attend, but he didn't enjoy that right, and so clearly his agreement at that hearing could not waive his right to a public trial subsequently. I would like to reserve the rest of my time for rebuttal.
Thank you.
Good afternoon, may it please the court. Emil Sama on behalf of the people. I will also waive my free fire zone. A while back, I was in front of here, and I and Justice Kavanaugh were both lamenting and reading transcripts as attorney and appellate judges. You just start screaming to your computer screen, "What are you doing? Stop it now." I'm there again on that one. Where in this regard, I wish the trial court would have put a better record on this. However, what I also find unique in this situation, and I think Justice Bernstein talked about with the balancing of interests, we're not just balancing the interests, we're balancing 2 constitutional provisions that's unique to Michigan. We are balancing the right to a public trial by a defendant under Article 1, Section 20, as well as the right to crime victims under Article 1, Section 24. And under that, it says the right to be treated with fairness and respect for their dignity and privacy throughout the criminal justice process, and the right to be reasonably protected from the accused throughout the criminal justice process. Some of that language is mirrored in 611A3. And what is also unique from when this case happened to today are unique rulings by the Supreme Court and this court when it comes to juveniles, specifically in Miller and its progeny. And what those cases have showed us is that the science has shown that minors do not have fully developed brains.
Doesn't the court rule and the statute strike that balance? And that's why we require trial judges to adhere to that.
Well, to a degree, but one of the arguments made by brother counsel was that there is no statute or anything because she didn't make that, she was too old for the 2163 and she didn't have a developmental disability under the other statute. So therefore, there was no basis to ever close this courtroom. Now understand, I'm not arguing for a blanket closure of a courtroom. That's absolutely inappropriate, right? There has to be the balance. And what's unique here, again, dealing with the neuroscience behind juveniles, also dealing with the type of crime you have here. A CSC case that I truly cannot comprehend what it's like to sit. I could not imagine sitting in front of 12 people and talking about consensual sexual experience and having them listen to me, much less a child who, even at 17, had to tell 12 strangers, 2 attorneys, under cross-examination and a judge, non-consensual sexual explicit details. Moreover,
And counsel, I mean, I think, I don't know that any of us would dispute that. I previously asked brother counsel about psychological well-being and whether that can be factored in, and I think a court can factor that in, correct?
absolutely. It's almost, in a way, dealing with a situation where we're dealing with these 2 competing constitutional provisions and realizing sometimes when the statute doesn't truly fully address them, as brother counsel stated, that there is some authority for the judges and the trial judges to take that into consideration.
Right, but we have a process for that.
Yes, we do, and the process was done when the prosecutor filed their motion alleging the issues that they had regarding the situation. And there were facts that were presented in the motion and that can be found in the preliminary exam, specifically that there was acrimony and a rift in the family who were taking part because of these allegations, that there were family members who were going to testify against the victim and they were going to be sequestered. You also had, during the preliminary exam and during trial, which we see afterwards, but at the preliminary exam, there was what I would consider or qualify as hyperventilation by the victim when she was testifying. Several times the preliminary exam judge said, do we need to take a break?
Were there alternatives provided? The consideration of alternatives provided, like you say, in the motion?
It did. I do not believe that there were the considerations of, for example, a screen could have been one alternative. I don't think Zoom would have been a proper alternative at the time.
What do we do with Davis? I mean, Davis says when it's preserved, the denial of a defendant's public trial right is structural error and it's automatic reversal.
I think it deals with the fact if it was properly or improperly granted, whether the closure was improperly granted. I would say in this situation that while the court did not give the proper wording on the record for what it should have said to determine the situation, the court considered it, it heard the arguments, it dealt with it, and it basically, implicitly adopted the prosecution's argument. So in this situation, if you're finding whether the prosecution's motion and the arguments that should have been done were improper and this court had no basis to ever close this courtroom, I can't stop that argument, and then yes, structural error would demand a new trial. However, I think when you're dealing with Klein, you're dealing with a situation here where the reality is there was no real argument other than my client has the right to public trial. Well, that is not absolute as any more than Article 1, Section 24 is
Isn't that
absolute.
just a gloss, though, on like a different way to say, well, it should have a, reviewed for error as opposed to a structural error that requires automatic reversal? I mean, of saying, well, it wasn't really erroneous, because if you look at it all, it ended up shaken out okay at the end.
Not necessarily. I would say that it's not erroneous because the basis for the closure could even still happen today. Even if a new trial were granted and this victim was still suffering, even though it's 7 years later, from the trauma from that situation, there would still potentially be a basis to close the courtroom today. I don't know. I'm speculating, as we would all do. However, would that change the analysis in the way that we go back, we do a new trial, the court puts better records, especially with whatever the victim is going through their day, that a closure of the courtroom is justified under all the standards? We've basically done a new trial and changed nothing. In such a way that a lot of the same arguments of why this child victim at the time should not have been subjected to a full-out open courtroom only during her testimony.
So that,
But
I mean,
let's-
the reason for it is maybe could be seen differently, but isn't the question of, is it broader than necessary? Like, that could be different, right, on a retrial? We don't know because it wasn't considered, and at least it's certainly not part of the record of was it broader than was necessary to actually advance those interests, even if we imply it or accept, what was made in the motion and all that. We don't have, that could be a different result.
I would say it was not broader than necessary in this situation. All that was done was the closure during the victim's testimony. The other option, of course, that pops in my head was a screen closing off the victim from the rest of the courtroom. But I think you achieved the same situation in this one where it was just closed during her testimony. All of his family members were sequestered because they were going to testify against her anyway. And there was no allegation that anybody was kept out improperly, as we dealt with, I think it was, I want to say it was the Davis case, but I can't remember exactly which one, where the defendant turned around to his friends and said, no, you have to get out. That's not the situation we had here. We don't have any of that here at all whatsoever. So we have a very limited situation where only the victim's testimony was kept away from the general public. His family members were already sequestered prior to that, as defense counsel at the time conceded.
So let's say we agree with you at this point and agree that the trial court should have had a hearing, should have walked through the factors, and didn't do so. Tell us where the path is to not issue an automatic reversal based on case law.
I think if we're looking at Klein especially, I would recommend that we adopt the Klein idea of remanding it back for at the very least, an evidentiary hearing, or the potential
But
of some type.
that was not a full closure. That was a partial closure.
Yes.
So you want
Yes.
us to extend Klein to a full closure?
At the very least, because again, if we're dealing with a situation here where this could happen again, even if there could be a different situation, whether it's a partial closure or total closure or other identities of a screen, the same thing is we could be going through another trial and still have the same result that would happen, albeit with a better record. And then we are basically redoing and re-victimizing somebody for basically putting one fundamental right over another. And I think when you're dealing with two different constitutional provisions and trying to strike that balance, there has to be some flexibility. And that flexibility is found all the time. This court adopted that flexibility when I found that 18-year-olds were also entitled to special protections of 769.25, even though that statute did not grant them that protection. You extended it.
But doesn't that argument sort of render the right to an open courtroom useless if you can always, after the fact, justify the closure?
Not at all. In the same way that you have the Miller situations and the LWUP situations where life without parole should be a rare occurrence, closure of the courtroom should be a rare occurrence. It is not an automatic right, nor should it even be one that's even raised without certain factual circumstances. To do so, I agree, would be completely improper and inappropriate. There is the rare situation that the courtroom closure should happen to protect the right, dignity, and privacy and undue harassment from a victim. And none more so than a minor under a CSC where there was evidence, at least on the record, from the preliminary exam and in the motion, that she had suffered from hyperventilation during the preliminary exam, was asked to take a break several times, had the acrimony and riff where the family members were even testifying against her during the trial, and the fear she had. That was part of the record, and nothing that trial counsel argued when he was opposing the prosecutor's motion addressed that, other than my client has a fundamental right to a public trial, and that's why it should happen. Again, I think when you're looking at those and we try to balance those interests, especially between two constitutional provisions, there is only the rare circumstance where even a motion should be filed to close the courtroom and after a search and inquiry. And I think that when this was decided, while you had Klein, you had Waller, you didn't have some of the new changes we have today, especially with the idea of juveniles and the neuroscience that happens with Miller, with Stovall, with Parks. It has definitely changed how we look at minors for all kinds, whether they are the accused or the victim. That science doesn't change simply by their label. And if we only give that one right to one side, it's akin to kind of a double standard.
Do we know whether any person not otherwise sequestered was denied entry? I mean,
No. None that were.
We don't know one way or another, or we know that no one.
Well, all the family members were, according to the record, were all sequestered for testimony. There was the ephemeral notion that there may have been two friends that wanted to come in, but
I
nothing.
don't think they were permitted in, though, were they?
I did not see anything where they were said not to come in, or somebody told them to leave, or any affidavits, or anything showing who these people were, if they were not, or they were told to leave, or anything. Nothing from the record showed anybody being removed or kicked out when the court was ordered that, because the only people that were out were those who were sequestered as witnesses. So the first time I heard about friends who weren't allowed in was in the brief on appeal. Unless there's any other further questions, I think I'll leave it at that. At the very least, I would ask that you deny the application at the most, rather than a new trial. At the very least, send it back for an evidentiary hearing to at least, under what Klein said, and extend it to the point to determine whether or not this truly needs to happen again.
And I'll ask you, I know you want to sit down. I'll ask you again, is there any case out there that you can point to that gives us a path to that? Other than Klein, because I think Klein is an extension. Is there anything out there that has dealt with this where you think that anything other than automatic reversal is an option?
If the court finds that this is a total closure under the statute, and I know I argue for partial closure, if you find it's a total closure, I think it's very difficult to find. There's no case, I think, that addresses that situation in such a way. However, I think given some of the ways that we look at some of the rulings of this court, it has not always been automatic reversal. The most common one to me was Lockridge. Right? Under Lockridge, when we found out there was a constitutional violation dealing with the defendant's right to be sentenced under constitutionally permissible material, the court, rather than granting a resentencing, modified it under a Crosby remand. and sent them back to determine if the court, without the unconstitutional restraint, should have still kept going forward, would have kept the same sentence. And if the answer was no, after being provided arguments by the defendant and by the prosecution, then the sentence is affirmed. If the answer was yes, then new resentencing is granted. I think something to that regard could still happen here.
Thank you.
Thank you.
Thank you. I will be brief. You know, as to remedy, the prosecution's argument that a deficient closure procedure can be ignored, where some basis for the closure existed that wasn't identified on the record by the trial court, that was the same argument that the Waller court rejected when it said we are not interested in post hoc justifications for the closure. And it's the same remedy that Presley rejected later on. Curing a Sixth Amendment violation here through remand would not only call for this post hoc justification from a trial court, but here in this specific case, it would require evidence, the presentation of evidence. So, and Globe makes clear that evidence would have to come in a public hearing. Weaver versus Massachusetts, that was clear. Where there is a preserved violation of the right to a public trial, automatic reversal is required because at the point of the objection, the judge has the ability to make the record. Mr. Veach timely objected, and the court said why it was closing the courtroom, and it wasn't based on any sort of compelling interest. It was because it didn't see a reason not to close the courtroom. Any public trial closure has to be narrowly tailored to further the identified interests. But a witness's constitutional right to be protected from Mr. Veach was in no way furthered by the closure because Mr. Veach wasn't excluded by the closure order. The U.S. Constitution doesn't provide for the protection of the rights and dignity of privacy of crime victims, and a rule that the prosecution has just argued for would create the blanket rule that minor sex crime victims are entitled to testify in closed courtrooms, and that directly conflicts with Globe.
Isn't there a federal statute that allows for that?
I'm not aware of that statute.
18 U.S. Code 3509 allows federal courts to close the courtroom when a victim of sexual abuse under the age of 18 testifies?
I presume it would still have to,
Make
any
findings.
ruling would have to conform to the Sixth Amendment.
Oh, I agree with that, but it seems to me that you just sort of made a blanket statement that that type of protection for young people would be unconstitutional. And that seems a little odd.
I don't think it's odd at all. Michigan obviously doesn't have this rule.
Well, the Michigan statute goes to age 16, right? Under 16. The federal statute seems to go to 18. So the point being that these are things that courts that concern themselves with, right? Protecting.
Oh, and Globe says this is a legitimate interest, and in some cases it's a compelling interest, is protecting minor victims. I'm not saying this isn't a valid interest. What I'm saying is a blanket rule that whenever a minor testifies about being sexually.
I guess my question is not just about a blanket rule, but the victim in this case, the allegation was repeatedly sexually abused by her own father, which is obviously an embarrassing and traumatic experience, if that occurred. And there's evidence in the record that that there's been a family rift, and that there was evidence that the assaults already had a psychological impact on her because she was suffering from depression and having nightmares and so forth. So there's evidence that was not, the judge didn't make findings, but there's evidence in this case from which the judge could have reached the conclusion that some type of closure might have been justified. Would you agree with that?
Not without more, because there's nothing about having to testify in public that has been presented in any part of the record. So yes, this was a traumatizing experience, and it might be embarrassing for her to testify in an open proceeding. But as I mentioned before, having eyes on a witness is a function.
I agree with you. It's a very important one. the confrontation clause. But my question to you is, what more do you need? What are you saying you need? You seem to be agreeing this could occur under certain circumstances. I agree that the judge didn't make the proper findings here, but what additional evidence would be needed in your view for a closure or some type of closure to be justified under the circumstances of this case?
At the very, very least, and I'm not sure this would satisfy it, but at the very least, some testimony from SB saying, I'm going to be traumatized to have to testify in a public courtroom. You know, I'm being intimidated. I feel uncomfortable. I don't think I can testify, you know, if Mr. Veach's friends are here. Something that ties the closure to the interest, and that doesn't.
And you believe there has to actually be an evidentiary hearing with testimony under oath to that effect, or is it sufficient if the prosecutor were to represent to the court that that's what the victim has indicated?
No, that's insufficient. Loeb says that's insufficient. There has to be a hearing where evidence is taken. This is what all the federal circuits require is an actual hearing on this matter. So, no, I mean, perhaps if the prosecutor could have pointed to testimony at the preliminary examination to this effect, possibly, but there isn't anything about that she didn't testify to anything.
Yeah, no, I understand. I'm just trying to understand what your view is, what the standard is, and what type of evidence is required. So, thank you, counsel.
Thank you very much.
Counsel, actually, before you run, really quick, how do you respond to the prosecution stating that maybe the courtroom wasn't really closed, that perhaps people were allowed in?
Well, you know, I think the court absolutely rejected that in Davis, that theory. And, you know, at the record itself, before she began testified, SB testified on 2 days of the trial. Before she testified on the first day, the prosecutor said, you know, we're closing the courtroom now. And then after she finished testifying on the second day, said, we're reopening the courtroom now. So, you know, I don't know. I know that this isn't a requirement of establishing a public trial violation. The judge's ruling prior to trial ensured that Mr. Veach's friends and family wouldn't come to court while SB was testifying. So
You're saying you think the record shows that it was clearly closed?
Yes, as Davis said, the courtroom was closed when the judge ordered it closed.
Okay, thank you.
Thank you.
Thank you. The case will be submitted.